Good evening, all, and welcome to the League of Women Voters webinar tonight. Are we a United States? Perpetual tensions in our constitutional system. If you were not coming here prepared to think and you're in the wrong place, maybe this is the time to go away because it's going to be a good evening full of facts. I'm Barb Stein. I'm chair of the League of Women Voters Johnson County Education Committee and co-host along with my committee members Ann Spencer and Galen Warburter. Tonight's webinar aligns with the mission of the League of Women Voters Johnson County, which states the League is dedicated to educating voters on political and ballot issues. We encourage informed citizen participation in government. Membership is open to people of all genders, age 16 and older. We invite you to join us. We can use your time, your talent, and your financial support for our ongoing operations. If you wish to learn more, please speak to one of our members or reach out to us through our website or Facebook page. I'd like to also point out that it is not necessary for webinars and forums for the League to be a member of the League. We think it's very important that we serve the public at anything like that, whether they're forums on political candidates or things like tonight. They're always, the public is welcome. In planning for tonight's talk, our committee kept coming back to, we'd talk about an issue and then we'd come back to saying, well, what's the big issue? What do all these things come down to? And we had a really good discussion one day, and we realized that every day we see things in the news, read them and hear them. And we wondered about things like, how can a state decide to defy the federal government? And how can voting rights be different in every state? And how can gun laws be different everywhere? What about K-12 education standards? No matter what the question, it seems those issues of control, both locally and at the state level, and American federalism pop up. We wanted to provide an opportunity for all of us to brush up on our knowledge of this important idea and to see how it is played into our history and still working today in our politics today. When we started investigating who to speak, all roads pointed to Professor Pettys. Every single person we talked to said, he is your person to talk about this issue. And of course, we were worried because when you hear a little bit about him, you're going to say, how does he even have time to do this? But we're very fortunate. Professor Pettys holds the H. Blair and Joan B. White Chair in Civil Litigation at the Iowa Law School. He joined the College of Law faculty in 1999. Some of his experience prior to that includes clerking for Judge Francis Murnaghan, Jr., the U.S. Court of Appeals for the Fourth Circuit, and private practice with Perkins Coie Law Firm in Seattle. He currently teaches classes on constitutional law and the Supreme Court, and is a prolific author of many, many articles and a book called The Iowa State Constitution. Many of you probably have heard him as a guest on Ben Kiefer's River to River on IPR. We are so pleased to welcome you, Professor Pettys. We ask that everybody mute yourselves. You can put your questions in the chat and Ann and Galen will watch for those. And I don't know about you, but I'm grabbing my pen and my paper to take notes. I'm very, very excited about tonight. Thank you so much for coming.
Barb, thank you very much. And I'll let you look at your screen and tell me if anything's awry or if I need to do anything. But that's a very gracious introduction. I've done a number of events over the years since, as you say, I came here in 1999. I've been fortunate to be asked by the League of Women Voters several times here in Johnson County or elsewhere in the state. And as I was telling someone earlier today, those honestly are some of my favorite events to do. It is a smart group of people, and it attracts people who are really engaged in politics and in the civic life of our country. And so it's always great fun. And I was flattered to be asked. I'm glad things worked out for us to be able to do this, even on Zoom. And so maybe we have even more people than we would if people had to get in their cars and drive to the local public library or something to join us. So I'm going to talk about federalism. It is, as Barb said, an issue that shows up all over our politics, shows up in litigation, but often I find kind of the vocabulary and the conceptual framework for understanding federalism is not widely known. And so I think it's, you know how if you learn a word for the first time, suddenly you start hearing it pop up in conversation. One of my hopes after tonight is that not just the word federalism, of course, but some of the concepts, a little bit of the theory underlying it, some famous examples that illustrate federalism disputes in action, that it will sensitize you to really the many ways in which federalism pervades our politics. It's a feature of our system. It's also a bug in some ways. It can be frustrating, federalism can be. But I want to present it to you tonight and kind of in the following way. I want to start with a little bit of history. I won't stay in history too long. We're going to have to go back to the Articles of Confederation, back when we first started trying to pull ourselves together as a country. I won't stay there very long, as you'll see in just a second when I pull up my slides. In fact, I'm going to do that as I speak here. Let me get my first one up and get to a slideshow. From beginning, and there we are. And Barb, you will undo your mic and let me know if you see any problems now or along the way, okay? But anyway, so I'm going to start just with a little bit of history about how what it means to call our system a system of federalism. So I want to define it kind of by telling you what it came from and a little bit of and then I want to tell you a little bit about the theory behind it. About why we have a constitutional system this way and kind of some of the big ideas about the opportunities and challenges that it presents to us. And then I want to just tell you some stories, a couple from far back in the nation's past, and then a few from quite recently, including some things having to do with COVID-related controversies, just to illustrate for you the range of ways in which federalism disputes can play out and some of the language and vocabulary, again, that's used when we talk about them. So I hope you find this interesting. So let me get us started by going back to the time of the Articles of Confederation. So, you know, July 4th, 1776, the nation was not yet a nation. The 13 British colonies declare their independence. And right within a month of that declaration, they're thinking, okay, so suppose we win. Of course, it wasn't at all assured that they would win the Revolutionary War, but suppose we win. What's our governmental system going to be? And what they did is align themselves together in a very loose federation, really as separate nations. You know, when you hear the word state, don't carry your current understanding of the word state back to the way in which they're using it. They really, those 13 colonies really thought of themselves as separate, as nations who would each of them being entitled to whatever benefits, for example, international law might provide to each of them as a nation. But they knew from the very act of revolution itself that there would be times when kind of aligning their interests with each other would be a good idea. And so the very first governmental system that they adopted that would try to pull these 13 colonies on the road to statehood, the Articles of Confederation was that system. And so let me just show you here a couple phrases, sentences from it. You get the flavor right here at the very beginning where it says the states, which is what they decide to call themselves since they're not going to be colonies anymore, hereby severally enter into a firm league of friendship with each other for some basic purposes. Okay, it's going to serve our interest in some ways. Okay, it's a very loose federation, as I say. They think of themselves as nations. And they give just a little bit of power to a separate government. You think of this today as the federal government, but it was in nothing at all that looked like our federal government today. The Articles of Confederation did not create a president, for example. It did not create a federal judiciary. There weren't courts. This thing called Congress that was going to be created was just a one chamber. It wasn't a House of Representatives and a Senate. Each state would be able to send a few delegates. Each state would have just one vote, and that Congress's powers would be really tiny. The states had all the regulatory power in the world. If they wanted to pass a law because they thought it was in the interest of society about your health or your safety or your morality, anything about your welfare, they could. And they surrendered very, very little of that power to Congress. Congress was quite an impotent institution. They could raise troops. Congress could. They could ask the states to send troops. They could declare war. They had a limited ability to negotiate treaties. They were going to be allowed to establish a postal system. They were going to be allowed to or empowered to resolve boundary disputes of certain kinds, between one state and another. But otherwise, that was it. So when you think about all the things that Congress today churns out, whether you agree with what they're churning out or not, all the kinds of laws that are, trying to bring to bear Congress's vision of public policy, that was not that Congress at the time. These were 13 separate, all-powerful states giving this little tiny Congress a little tiny power, a little tiny bit of power, and that was it. Okay, well, it didn't take long for the system to run into trouble. Congress had no ability to raise money, for example, no power to tax. And so if they want to pay for a war or try to pay the war debt from the Revolutionary War, all they could do was ask the states, would you please send us some money? And the states could do it or not. And if they didn't want to do it, there were no repercussions. And so at first the states paid when Congress asked, but as the years went by, more and more states started paying less and less money. These states, because they thought of themselves as nations, they kind of behaved as nations. Think of nations today getting into trade wars. One nation decides that it's going to impose some kind of tax on imports from a different country, and that other country is not happy about it, so they retaliate with taxes that are imposed on the other country's goods coming in. The states did the same thing. They engaged in trade wars with each other. If a ship was trying to come through a harbor or up a river that another state claimed as its own, that other state would say, you have to pay a fee to pass through these waters. And so it really was an enormous drag on the economy, and it really started to drive these 13 different states' economies into a ditch. And that's what started the talk about, maybe we need a different constitutional system. And it was a little slow to get going. James Madison was among those who thought that, at least from an economic perspective, we've got to come up with a different system. And there's a false start or two, but ultimately it leads to the Philadelphia Convention, and which produces the Constitution that we have today. Now, one of the very first things, the very first words of the Constitution, which I have here, we the people, speaks in a very different language. Let me just back up and remind you what we had here in the Articles of Confederation. Here in the Articles, the states were the speaker. They were the narrator of the story, if you will. The first provision of the article says, the states hereby severally enter into this firm league of friendship. But when we get to the Constitution that comes out of Philadelphia and is ultimately ratified, we have a different speaker. It's we the people of the states. And so we hear this voice of the people that's almost speaking, in fact, is speaking in a way that kind of transcends, in some important ways, state boundaries. And so we the people all together are joining to, not, women, non-whites, non-property, all kinds of questions there, of course, okay? But still, the shift from states doing the speaking to people doing the speaking, we have a new speaker who are going to establish a new federal government, and it's the federal government that we have today. There's going to be a president. There's going to be a judiciary. There's at least going to be a Supreme Court, and there's going to be as many other lower federal courts as this new Congress might want to establish. Congress is going to be different. It's going to have two chambers. There's going to be a House of Representatives, and there's going to be a Senate. And the Congress is going to have some important powers. All right. Like the prior Congress did not have under the Articles of Confederation. This Congress is going to be more powerful. How much more powerful? Well, that was a subject of great debate, just as it continues to be now, but it's certainly more powerful than the thing called Congress that preceded it. Now, the significance of state boundaries did not go away. This document, the Constitution, was ratified state by state by state. And when you think about our politics, all of our interactions with the federal government today happen through our states. Within our states, we vote for United States senators. Within our districts, which are housed wholly within states, we elect representatives to the House of Representatives. When we vote for president, it's through the electoral college system. And so on election night, we see the results come in state by state. We never have a national election about anything. There's no occasion where the people, setting their state identities aside, speak. We don't have national referenda like many states have, where you get enough signatures on a petition or something, an issue can be put to a vote. We don't have any of that. And so it's still through our state identities that we interact with this federal government, but there is going to be this federal government that's going to have some significant power. Okay, now a couple more things. I was looking just for visuals. I'm not trying to sell you t-shirts, but if you like the language of the 10th Amendment, this is yours for just $17.99 on Amazon, I discovered. So here's your image, but it's not the t-shirt I want you to see, it's the 10th Amendment. And so the last provision of the Bill of Rights, which came in very quickly after the Constitution's ratification, makes explicit this really important principle about the powers of the federal government. I've got just one or two of these things to show you, and then we're going to step back and look and see, aha, now we can really kind of define what federalism means. So first, what we have to see here is that in the Constitution, it says that the powers not delegated to the United States, in other words, the powers not delegated to the federal government by the Constitution, are reserved to the states. So in other words, we're not giving all power to the federal government, we're giving them some power, but whatever power is not delegated, those super powerful states get to keep. Okay. The other principle that kind of sits alongside, there's no t-shirts for this. So if you want to go in the market, there's a little opening here, the Supremacy Clause of the Constitution. This Constitution and the laws of the United States, which shall be made pursuant to the Constitution, shall be the supreme law of the land. So you put those two constitutional texts next to each other and we say, okay, the federal government only has limited powers. There's only certain things that it can do. But when it does do them, when it does pass laws, take actions that the Constitution authorizes, then it's the supreme law. And if there's any conflicting state law, then that conflicting state law has to be shoved aside. All right. So what does that mean? Well, here's what federalism is. Here's what it means in this country. I've just singled out, I want you to have the image here of the country with all of its different state identities. We just single out Iowa. So that's probably where most of us are listening to this listening from tonight. You think about the state of Iowa. Here it is in red. It's a geographic space. What federalism means simply is that within this geographic space, there's two governments. There's two sovereigns, if you will. There's two governments. There's the state government of Iowa, and they have power to regulate what is happening within this geographic space. Now, this geographic space also happens to fall within the borders of this larger geographic space, which the United States government has control over. So for those of us here in Iowa, we can find ourselves being regulated by politicians in Des Moines, kind of the state level politicians, or by federal politicians in Washington, D.C. And so when we speak of American federalism, what we mean simply is that for any given geographic space, there's two different governments that potentially could be regulating what's happening in that space. You contrast that with just a centralized system of government. If we didn't have a system of federalism, what we probably would say is that the federal government has all power, it can do whatever it wants, and it can use state political machinery, state bureaucracy, state lawmakers, even if it wishes, kind of as pawns, as tools, and they can move those pieces around as they see fit. That's not our system. Federal government has limited powers, but within that realm, it's supreme. And then whatever's left, the state has. Okay, now Justice Kennedy, in a case that I'll be coming back to a little bit later, described federalism. I know there's a lot of text on this page, but I hope you'll find that it's worth it because he kind of nicely summarizes the system that gets created by what I've described here. Justice Kennedy, in a case, again, I'll talk about closer to the end here, federalism was our nation's own discovery, he says. The framers split the atom of sovereignty. It was the genius of their idea that our citizens would have two political capacities, one state and one federal. I'll come back, but just that's exactly what I was saying there about state of Iowa. Those of us here in Iowa, we have two different political capacities. There's the state policy making machinery, and we can invoke that in many, many instances in ways that we find beneficial. We also are members of the larger United States, and there's a federal policy making machinery, and we can try to invoke the benefits of that. So we have these two different, we can vote in state elections, we can vote in federal elections. So we have these two different political capacities. The resulting Constitution, Justice Kennedy said, created a legal system unprecedented in form and design, establishing two orders of government, each with its own direct relationship, its own mutual rights and obligations to the people. Now, I want to ask, so that's the kind of the history of how we got here and definition of some terms, what we mean by federalism. So now I just want to think just for a few minutes here about theory. Why? Why create this system? Does it have certain benefits? What was the idea? Well, just on a superficial level, one thing we can say right away as a possibility is, well, under the Articles of Confederation, the states had discovered that if they kept all the power for themselves, this alliance wasn't going to work. They were going to be fighting with each other. No one would be contributing financially to the good of the larger whole. And so we need to create a government that's going to have more power. But we want to keep as much of it as we can, but we'll give a little bit to the federal government and thereby set up this federal system so that within the state of Maryland, for example, one of the original 13 states, the Maryland government will still have a ton of power, but the federal government will be able to come in some appropriate instances, and they could regulate in that same geographic space too. So it might just be as a practical matter. They thought, well, we the states want to keep as much power as we can, give the federal government at least enough power to solve the problems we've been confronting. That's one possibility, but there's deeper theories about exactly what's going on here. And one of those theories is spelled out in the Federalist Papers. And if you know much about American constitutional history or the founding era, you will know that the Federalist Papers, it's 80 or so essays that were written by some important people, Alexander Hamilton, James Madison, and John Jay, kind of trying to defend provision by provision, and then the document as a whole, this Constitution that was drafted in Philadelphia. There were essays written, you can think of them as kind of long, quite intelligent essays, op-eds, if you will, written especially for readers in the state of New York, urging a yes vote on ratification of this new Constitution. Okay, so they're trying to urge people to vote yes. And so they talked about the Constitution in broad terms. What is this Constitution that we're asking you to vote yes on in order to ditch the Articles of Confederation? And then they would go provision by provision saying, here's what this means. Here's what we're trying to do here as we understand it. So they're frequently consulted for insight, at least among some of the thinkers at the time, about what the Constitution was aiming to do. And you can see here in the text that I have to write, when it comes to the issue of federalism, why create a system of federalism? What these important authors imagined was that the states and the federal government would be competing to win your heart and to win your trust. Okay, and so here's how this would work. There's going to be some areas where the Constitution doesn't allow the federal government to act at all. There will be some areas where the new Constitution does not allow the states to act at all. Okay, one area of that, for example, would be when it comes to immigration rules and a rule of naturalization, how you can come from another country and become a citizen here. The Constitution says that's for the federal government, it's not for the states. Okay, so there'd be on one end of the spectrum, there's going to be some things the Constitution only will let states do. Say, we're not giving the federal government the power to do X, only the states can do X. There's going to be some other things that the Constitution says that only the federal government can do, but then there's going to be a big thing in the middle, and that's where the federalism payoff is on the theory that I have kind of highlighted here on the screen. And the idea there is there's a whole bunch of things where we have a choice. We could turn to state leaders and ask them to tackle the problem, or we could turn to federal leaders and ask them to tackle the problem. And these authors said those two different governments, as I said a second ago, are going to be competing to win your heart, to win your trust, so that when you have some regulatory business to do, there's a public problem that you want solved, you will say, look at those lawmakers in Des Moines. They really can get it done. We ought to be turning to them for our regulatory business and come to them and ask for the laws we want. If we become disgusted with state lawmakers and say, oh my God, they don't think like we do, they don't act like we do, I don't know, what drugs they're on or something, but that's not where we want to do our regulatory business. Let's go to the federal government. We're going to get better, more competent help there. If that's our view, then we turn to the federal government. Okay, and so they said through elections, elect politicians who are pledging to regulate in particular ways, politicians who are pledging a smaller federal government or maybe a larger federal government. We can size these politicians up and try to move power back and forth, turning to the states during some eras for some problems, turning to the federal government in some eras for other problems. James Madison, I don't have it up here, said in a line I'll just read to you. James Madison in one of the Federalist Papers says that surely the people should not be precluded from giving most of their confidence where they may discover it to be most due. So if we think that we're going to get more likely to get what we want from the federal government, then for all those issues that sit in the middle, where the Constitution says you could have the states do it, you could have the federal government do it, which do you want? For all those areas, who do we trust? Okay, so that's one important theoretical grounding for federalism. And then there's some other things too. For all of those issues in that big middle where we have a choice between what I'm calling here regulatory pluralism versus regulatory nationalism. And what I mean by that is simply there's going to be some issues where we can imagine a number of different reasonable ways in which a problem might be tackled. And for those things where we say, I don't know exactly what the right fix is here, there's probably a range of ways in which something could be effectively done. For those issues, maybe we say, let's turn to the states for those. And each state can kind of chart its own path. There'll be other issues where we say, if we think of ourselves as one people, if we think of ourselves as one nation, then surely there's only one answer to this question. And for those kinds of questions, whichever questions we put in that category, maybe we say, we want one national rule. I'm going to talk about slavery here in a little bit. And ultimately we say, we don't want states making up their own mind about slavery. We want one national rule. We end up, as I'm going to show you a little bit, as you already know how that story ends, we're going to get rid of slavery as a matter of a national rule. When we choose the regulatory pluralism path, I've got the laboratory graphic there, we talk about states being able to experiment. There might be certain things about education policy, about drug policy, about marijuana for usage, for example, about welfare policies, about unemployment approaches. There might be some areas where we say, boy, there's different things we could try. Let's have states kind of chart their own paths and kind of run some experiments, basically. And then it's some years down the road, we can ask each state, well, how'd it go? And if we find that there's one approach that works really well, maybe we'll take that approach and say, you know what, let's adopt that on a national level. I've got the little footprints there to suggest that for all of those issues that we put on that side, where we say, let's let the states chart their own paths on this, then at least for people who are mobile, which takes some resources and some job opportunities to do, so this is not available to everybody, but for those people who have the luxury of being mobile, they can vote with their feet. And so if one state starts to tax people in a particular way, adopt certain policies about K-12 schools, adopt certain policies about drugs or something like that, and you don't like it, you can say, well, where are they doing it better? And you can then shop, head to a different state. If you put all of those things together, the stuff about the Federalist Papers and voting with your feet and what Justice Kennedy is talking about, splitting the atom of sovereignty, one thing that unites all of that is the idea is that federalism is one important principle that makes you more free than you would be in its absence. That's the idea. You may be persuaded by it, you might not be persuaded by it, but the idea is you are more free because of the options that it gives you. Okay, there's not just one lawmaker that has all power and you're stuck with whatever they do. So you have some freedom. Now, there's one other thing before I start telling some federalism stories here about how all these things play out, and that's the role of partisanship. Partisanship, especially in this day and age, since that's such a prominent part of our politics now, partisanship and our partisan identities, to the extent we claim them, if we think of ourselves as Democrats or if we think of ourselves as Republicans in particular, federalism interacts with that in some important ways. One thing that federalism does then is it gives hope to those whose party loses power at one of the two levels, at one of the two sovereigns. So if you are a Democrat, for example, in Iowa now, where Republicans have quite a strong hold on government, well, you can always hold out hope that at the federal level, the Democrats are going to win the White House or one of the two chambers, if not both, of Congress. And so if you get shut out on partisan lines from one government, okay, you're a Republican and you lose at one of those levels, at least you can turn to the other and say, well, what can we get done here? Can we claim some power over this policy-making machinery? So it does that. It also, and kind of a different way of thinking about the impact that partisanship has is, you can come at these issues and say, You know, as a general matter, for example, I'm all for a smaller federal government. These distant politicians in Washington, D.C., they don't understand us back here and so forth. And so smaller federal government. But if lo and behold, your political party wins power in Washington, D.C., it can be pretty easy to shove those principles aside. Maybe you'll stick with them on some issues, but on some others, you might say, well, while we've got the policymaking power, it might be kind of nice at the federal level to kind of do what we want nationwide. And so kind of principled sounding bases for saying that as a matter of federalism, the following issues should only be regulated at one level or another. Sometimes you can find people loosening their attachment to those principles when their political party wins or loses at the state level or at the federal level. Okay, so those are some lenses on federalism. Now, I just want to tell you some stories here. Some short stories. The slavery story is a little bit longer. That's going to be the second one that I tell. But just to show how right out of the gate in nation's history, federalism issues flared up in a big way. This is a short story, easily told. So here's our players. We've got the United States Supreme Court. I have a photograph, or a painting rather there, photograph. I've got a painting there of Chief Justice John Jay, just to symbolize the United States Supreme Court. And here's some Georgia soldiers in the Continental Army during the Revolutionary War. During the Revolutionary War, Georgia bought, essentially, it's a long story, but let's set that part of it aside. They ultimately bought some clothing and some blankets and so forth from an out-of-state seller, a seller in South Carolina. So there's a guy who's selling clothing and blankets. Georgia buys some stuff from him during the Revolutionary War. After the Revolutionary War, Georgia refuses to pay the bill. They say the guy who sold it to us was a British loyalist. He doesn't deserve to get paid and so forth. And so the guy who never gets paid files a lawsuit and says, you owe me some money. Okay. Now, he filed that lawsuit in federal court. So to follow this little story, here's the one piece of it that you got to make sure that you understand. He filed it in federal court, which means it's one of the courts that's created by this brand new Constitution. This is 1793. Okay. The Constitution had just been ratified, 5 years earlier, 4 years earlier, 4 or 5 years earlier. So it's a brand new Constitution, creates a president, creates this new, bigger Congress, authorizes that Congress to create some courts. And the Constitution itself creates a Supreme Court. And it's in those federal courts, not state courts. State courts existed. This guy said, you know what, I'd rather sue the state of Georgia in a federal court rather than in a Georgia court. I think I'm more likely to get a hearing. And when you go to the Constitution and ask, does this federal court have power to hear this guy's case? There's language in there that seems to make it look like an easy yes. Because the Constitution says the judicial power, and that's Constitution speak for the power of the federal courts. So the power of these newly created federal courts shall extend to controversies between a state like Georgia and citizens of another state, like our blanket and clothing seller in South Carolina. So if you read that, you think easy case, right? If someone's going to ask the question, can a federal court hear this lawsuit, or do they have to shove this aside and say, boy, this lawsuit's got to get filed in state court? You read that, it seems pretty easy. And so John Jay's Supreme Court, in one of its first significant rulings, they're kind of trying to find their footing, figure out what their role is. He said, yeah, this guy can sue Georgia, and Georgia owes. And so Georgia, pay the guy what he owes. State of Georgia, pay the guy what he owes. And the nation basically explodes. Hyperbole, of course, but there's an absolute outcry that how dare this new federal court tell the sovereign state of Georgia what to do? How dare it tell the state of Georgia that it needs to pay as much as a dime to this guy from South Carolina? And so we get our very first amendment to the Constitution, which is still good law today. Our very first amendment to the Constitution that comes after the Bill of Rights. So the first 10 amendments are the Bill of Rights. They come to us very quickly. They're kind of almost part of that same original ratification package. The very first amendment that comes after that is the 11th Amendment. Note the year, 1795. The decision in Chisholm versus Georgia came down in 1793. So very quickly, the nation leapt into action and said, the judicial power, that is the power of the federal courts, shall not be construed to extend any lawsuit brought against one of the states by citizens of another state. Just rejecting Chisholm. That's a federalism dispute, okay? Because it's a question hear about the power of the federal courts, this new federal government. We've got a battle between them and the state. Who has the right power here? And the John Jay's court had apparently the audacity to think, well, under our federal system, the federal courts can tell states that they have to pay money. And the 11th Amendment comes along saying, absolutely not, you can't tell the states what to do. That's a federalism dispute. Now, a more conventional federalism dispute, and parts of this story are going to be more familiar, parts of it I hope less so that I'm making good use of your time, is slavery. And the story of slavery in this country is in many ways a story about federalism, with power moving back and forth. Should we treat it at the state level? Should we treat it at the national level? No, we should treat it at the state level. And here's just quickly how that story plays out. All the language that I've got here in on the screen is all language from the original United States Constitution. And so in one part of the Constitution, it says Congress has the power to regulate commerce with foreign nations and among the several states. Remember how the states were in trade wars with each other? Here's some language telling Congress that it can put out those trade war fires. But also, if Congress has the power to regulate commerce with foreign nations, that means people who are bringing in slaves from other countries, Congress could regulate that. But there's a different part of the Constitution that says, and it's a slavery provision, the migration or importation of such persons as any of the states now existing shall think proper to admit. So think slaves. The importation of slaves that a state wants to permit shall not be prohibited by Congress prior to the year 1808, but you can tax them, okay? So until 1808, Congress cannot regulate the slave trade. So it's saying until 1808, whether we're going to do slavery, whether slavery is going to be permitted, whether we're going to allow slaves to be imported, that's a state matter. It's a matter for each state to decide. Congress can't regulate it, at least, as I say, until 1808. Okay, well, now we have the Missouri Compromise of 1820, not long after 1808. And the Missouri Compromise, there's a debate, as many of you will know, about when the state of Missouri here gets admitted as a state. Should it be admitted as a slave state or as a free state? And that's something Congress is deciding state by state by state as the nation grows and states are added. Congress is having to make a decision. Are we going to allow slavery there, or are we not going to allow slavery there? And the Missouri Compromise drew this line, which I hope you can see on my cursor, this line that runs along the southern border of Missouri. And it says that with the exception of Missouri, Missouri will be admitted as a slave state. If Missouri wants slavery, they can have slavery. But with the exception of that, all of this kind of peach-colored territory up above it is going to be free. So this territory will be free. Any states ultimately carved out of it, such as Iowa, which is going to come right here one day, okay, it's going to be free. That's what the Missouri Compromise of 1820 says. Missouri will be slave state. All the rest of this land, whether it remains a territory, whether it becomes a state, no slavery there. So that's a federal rule. You think about it from federalism. We're saying, Missouri, you can decide slavery on the state level. Future states, future territories coming out of this chunk of land, we have a uniform national rule. It is not up to you to decide on slavery. Well, that becomes controversial as time goes on, as we work our way up to toward the Civil War. In 1850, the new land that had not been part of the Missouri Compromise, the Utah Territory and New Mexico Territory, in 1850, Congress had created those territories and said they can, for those areas of the country, they can decide slavery at the local level. If they don't want slavery, they don't have to have it. If they want to have slavery, they can have it. And this 1854 statute called the Kansas Nebraska Act took that big peach-colored territory, by and large, that the Missouri Compromise had said would be free, and abolished it. Got rid of the Missouri Compromise and said these territories and all states eventually carved out of them will be able, it'll be a local choice. They can decide for themselves what they want to do about slavery. Okay, now we get to Dred Scott in 1857. Dred Scott's a complicated story. It's a long story. There's lots of legal issues in it. I'm going to focus just on one. So we had the We had the 1854 legislation here, Kansas, Nebraska. Just a few years later, we're up in front of Roger Taney, Chief Justice Roger Taney. So there's an image of him, his Supreme Court. And here's Dred Scott. Dred Scott, his claim, he's a slave in Missouri who claims his freedom. And his claim to freedom rested in part on the fact that his owner, who was a surgeon in the US Army, had taken him into the territory of Wisconsin, which was part of that Missouri Compromise land prior to the Kansas Nebraska Act ditching the Missouri Compromise. And so the territory of Wisconsin was free. And under a set of understandings about what happens when a slave owner brings a slave voluntarily into free territory, there's a widely understood principle going all the way back to British common law that slave suddenly becomes free. And so Dred Scott said, well, under the Missouri Compromise, that broad national rule that said all that area up there is no slavery allowed, my owner took me there voluntarily. And so I became free at that moment. And one of the things that the Dred Scott court then had to look at was, or just, they didn't have to look at it, they decided to look at was, now that Missouri Compromise, I know we've ditched it now, it's no longer a good law, but while it was in force, did Congress ever really have the power to pass it? That's a federalism question. Does Congress have the authority to declare a rule about slavery in these territories and states? Or is that something that has to be left at the local level, the state level, the territory level, if you will? Now, if you go to the Constitution and look at it, there's language here that would seem to make it very clear that Congress did have the power to pass the Missouri Compromise and designate that enormous chunk of land as free territory, because the Constitution says Congress shall have the power to dispose of and make all needful rules and regulations respecting the territories of the United States. It seems, straightforward enough, I think. Congress has the power to pass the Missouri Compromise. Roger Taney's court looked at that and said, you know what, it doesn't mean what you might think it means. When it says Congress has the power to make rules for territories, that word territories doesn't apply to the territories that we just saw there on the map. That just refers to 3 or so tracts of land that were disputed at the time of the Constitution was adopted. A little bit of the land was in Virginia, I think, and a couple in some other places. It was just those little pieces of land. This wasn't about the Missouri Compromise. And so the Dred Scott court said Congress never had the power to pass the Missouri Compromise in the first place. It was never good law. It was unconstitutional all along. And so in the eyes of Roger Taney, the slavery question is necessarily a local question. It's not something that the federal government has the power to control, especially in the territories. It's something that they have to be left the power to decide for themselves at the local level. Well, you know where that story ends. Ultimately, we have the Civil War. And then we have the 13th Amendment to the Constitution, where, again, thinking about this through a federalism lens, we decide we don't want regulatory pluralism. We don't want each state deciding for itself anymore about slavery. On this, we want one national rule that everyone's going to have to abide by. And so we have an amendment to the Constitution that flatly declares no more slavery. So there in that story of the story of slavery, you can see this movement. It's a state or local issue, and then it's understood to be a national issue if Congress wants to reach it. And then the Taney court says, no, it's not. It's a state or local issue. And then we have the 13th Amendment saying, no, slavery is going to be a national issue, and we're not having it anymore. That's the longest of the stories I want to tell you. I want to focus just quickly here on just a few more things. I want to turn to the next amendment, the 14th Amendment. Now, when you think about federalism, and we can take you back to kind of the early part of my little talk here, at the time of the founding, the states again understood themselves to have basically all power, any kind of regulatory power that they wanted to exercise as a general matter, they would have it. They did delegate to Congress the authority to act as well. But when you read through the Constitution as a whole, there's a little bit in it about limitations on states, but not much. The 14th Amendment, adopted soon after the 13th and after the Civil War, began to speak about the states in a new way. And when you look at this text, which is going to be very familiar to you once you kind of work your way through it, some very important restrictions being placed on the states now for the first time. The first sentence gives us a rule of citizenship. That rule, that sentence rather directly overrules some other parts of Dred Scott that we haven't talked about, which is, what it takes to become a citizen. And then the second sentence of the 14th Amendment says no state. So think about this again through a federalism lens. At the national level, we're adopting a rule saying on certain matters, states can't do what they want anymore. In what areas can they not do what they want anymore? Well, they can't make any law which abridges the privileges and immunities of citizens of the states. They can't deprive you of life, liberty, or property without due process of law. And they can't deny you equal protection of the law. And then at the end of that amendment, we give Congress more power and say, Congress, we know you're a government of limited enumerated powers, but here we're going to enumerate another power for you. You have the power to enforce everything you read up there in Section 1. So if you think that someone's due process rights or equal protection rights, for example, are being violated, you can pass some statutes to try to tackle that problem. Now, so when you read this text, you would think, wow, this is a pretty major sea change for the country. These are areas where, if it has to do with equal protection, due process, privileges, and immunities, states have just lost power to do what they want. And power is being shoved to the national level. We have a national rule that Congress, the federal government, is now authorized to enforce so that we have nationwide uniformity about these things. It looks like a major sea change. Okay. Eventually it is. But this is 1868. We're well into the mid 1900s before that sea change really starts to occur. And I just want to tell you one tiny little piece of that story. It won't take long at all. If I were to ask you, here we have the Privileges and Immunities Clause. Here we have the Due Process Clause, and here we have the Equal Protection Clause. 3 clauses. If I were to ask you, which one of those sounds less familiar to you than the others? My guess is you would say the Privileges and Immunities Clause. I don't know that much about that. I know about due process. I've heard about the Due Process Clause. I've heard about equal protection. I know a little bit about that, I think, but privileges and immunities I'm not so sure about. Well, here's why. I'm just going to tell you why you don't know much about the Privileges and Immunities Clause. That's because there's not much to find out. And the reason there's not much to find out is the Supreme Court killed it pretty quickly. Let me just tell you that through that story through the federalism lens. So the 14th Amendment is 1868. We're here in 1873, just 5 years later. Okay, so every justice on the court that decides this case, which are collectively called the slaughterhouse cases, all of these justices lived through the Civil War. They lived through the time of slavery. They lived through the ratification of the 13th Amendment. They lived through the ratification of the 14th Amendment, and they lived through it at a mature age. They knew all these things. They experienced all these things as adults, and they see the 14th Amendment get ratified. So just 5 years later, I'm not going to go into the facts of the case. It has to do with butchers and some things that were happening in Louisiana. The one little thing that I want to focus on here is the Privileges and Immunities Clause. And some claimants in that case said, and again, I'm not going to get into the facts of the case because they're not important for what we're trying to do here tonight. All you need to know is that some people pointed to the Privileges and Immunities Clause and says the state of Louisiana is violating my privileges and immunities. And the 14th Amendment says that that can't happen. This is the first time that the Supreme Court is asked to look at the 14th Amendment, any part of it, and say what it means. So it's an important case in that sense. It's the first time the Supreme Court gets a case where someone is pointing to one of those 3 clauses, either equal protection, due process, or privileges and immunities. They're pointing to one of those clauses and saying, here you go. Here's our first example of a state violating the 14th Amendment. Now, don't gasp when you see the next slide. This is a ton of words, I know, okay? And if you want to take the time, like a good League of Women Voters audience probably is, and you want to take the time to read through this, have at it. There's some clauses, and so that's why I've got the whole thing up for you. But what I want to pull out here are just some phrases. And the big picture that I want you to see here is how horrified the court is by the notion that the 14th Amendment really changes things from a federalism point of view. When I had the text of the 14th Amendment up there on the screen, I was saying, wow, look, this looks like quite a sea change. Some big important areas where power is being taken away from the states. It's things they can't do anymore. And Congress is being given the power to regulate and to protect those rights. And now, so here comes some claimants, and they say, well, if we rule for the butchers, those were the guys claiming that their privileges and immunities rights are being violated, this court, would become a perpetual censor upon the legislation of all the states. We'd be reviewing all these state laws all of a sudden, striking some of them down. Can you imagine the court striking down laws of states? And they say, wow, the consequences of that would be so serious, so far reaching and pervading, so great a departure from the structure and spirit of our institutions. Look at this. When the effect is to fetter and degrade the state governments. Think about that language, fetter and degrade. This is a generation of slavery. These people knew the imagery of slavery. They knew what it looked like for a slave to be stood up in front of a bunch of people, manacled, shackled, fettered, stripped, degraded. And it's exactly that language that this court says, wow, we can't fetter and degrade the states by suddenly having courts coming along, reviewing, people's claims that the states are violating the law. And so in a larger story, which I won't take the time with, they read the Privileges and Immunities Clause in a way that basically erases it from the Constitution. It's virtually dead, which is why you know all about the Due Process Clause, perhaps, you know all about the Equal Protection Clause, but in the very first shot, to kind of attempt this. And so one thing I want you to take away from this, and then I'm going to move on to my next story, is these federalism changes are hard, even when the text seems pretty clear. I told you the story about state of Georgia being sued. Recently ratified constitutional text had seemed to say that some power was being given to the federal government. And the Supreme Court read the text in that case and said, well, the text seems pretty clear. And the nation said, oh my God, we can't have that. So let's quickly amend the text. Here, the Supreme Court kind of takes the opposite approach. They read the text, which seems pretty clearly to take some power away from the states and move some power to the national level. And the Supreme Court says, what a humiliation for the states. We can't have that. Okay. All right. Let me tell you a couple more stories. This is a League of Women Voters story. All right. I'm moving up now to the modern era. I'm just going to take a few minutes for each story, not too long. And then we'll have some 10 or 15 minutes here for questions. On the issue of term limits, the state of Arkansas decided that it wanted to put term limits on its representatives in Congress. And it was actually a League of Women Voter member who filed that lawsuit saying that term limits are unconstitutional. And the League of Women Voters as an organization filed an amicus brief on that same side saying that Arkansas cannot limit the terms of representatives and senators. And the Supreme Court struck that down 5-4. This was the case where Justice Kennedy wrote that language I showed you earlier about federalism being the nation's discovery. And so now if you can just remember a little bit about that, about how we have two different political capacities, this is kind of a model of what he imagined. This is federalism as he understood it. I said it was a 5-4 decision, and if you can still see the tiny font up there, the New York Times has that in the headline too. It's a 5-4 decision. And basically what the court says, and Justice Kennedy agrees with this, is that here's federalism. Okay, so we've got the people. Here we are in Iowa, okay? We have our state political capacity, we've got our state government, and we've got the federal government. According to the US Term Limits versus Thornton Court, the entire federal government represents all the people. Here's what I mean by that. Do you have a United States Senator from Arkansas who you're kind of a fan of? In the House of Representatives, Nancy Pelosi, you probably have some feelings about her. Mitch McConnell in the Senate, you probably have some feelings about him. Neither of those congressional leaders are from Iowa, but probably my guess is one of them or the other you'd probably like to see lose their next bid for re-election, and the other one perhaps you'd like to see win. So you feel your interests are served. Chuck Schumer, what do you think about Chuck Schumer? Ted Cruz, what do you think about Ted Cruz? And so what the United States Supreme Court says is all those politicians, Ted Cruz, Chuck Schumer, Nancy Pelosi, Mitch McConnell, all those politicians, they represent all of us. And so when Arkansas comes in and imposes term limits on its representatives, it's interfering with our ability to be represented by those people, even though they're elected in another state. If that doesn't gel really easily, let me contrast it with the model of the dissent. This looks complicated, but as I talk through it here for a second, you're going to see that it's really not. The dissent, this is Justice Thomas writing the dissent, he says, no, that's not how federalism works. Here's how federalism works. We, the people of Iowa, we have, yes, we exist, we live here in the state of Iowa. We have a political identity as Iowans, and it's only through our Iowa identity that we have any connection to the federal government. We elect United States senators here in Iowa. We elect United States representatives here in Iowa. We will cast our votes in presidential elections, which will run through the Electoral College machinery here in Iowa. And that's our only connection to the federal government. So on this view, if the people of Arkansas over here want to change something about how they elect their representatives to the federal government, well, that's between those people of Arkansas and the federal government. It doesn't affect us at all. Those are two different, very different ways. And again, it's a 5-4 split about which of these is our system, where all the people are represented by the entire federal government, and we have this direct relationship with the federal government, with regardless of our state identities. Or is our relationship to the federal government more limited through like a very conservative, almost kind of priesthood model, where the states are there as our representatives, they're the voice through which we speak to the federal government, and what's happening in other states really doesn't affect us too much. Okay, different conceptions of federalism. Here's how I'm going to end. Okay, 2 COVID-related cases, one from 2021 and one from 2022. Federalism is going to pop up here in a different way. Okay, in 2021, the United States Supreme Court struck down on kind of party lines, if you want to think of the justices and their identities by virtue of the political party of the president who appointed them. You just kind of, so the court's dividing here on familiar lines. The federal government had issued a moratorium on evicting tenants during COVID. The theory being, among others, in order to prevent the spread of the virus, we shouldn't allow landlords to kick people out, and then those people are going to have to go to other places and so forth. We should let them stay in their home, where they can kind of closet themselves in their home and wait for the pandemic to pass. And the Supreme Court struck that down as unconstitutional. So let's think about this through a federalism lens. We had a national rule, a federal law level rule, saying in no state are we going to allow landlords to throw out their tenants during this time. Okay, the Supreme Court said that's unconstitutional. One of the reasons that they pointed to was they said when it comes to landlord-tenant law, they had more reasons than this, but in the interest of time, I'm just going to focus on this one, and it ties directly into our federalism theme here tonight. When it comes to landlord-tenant law, that's an area for state regulation. That's where the states have always been the main player. And we're not saying that Congress can never interfere there, but as we read the legislation that the Biden administration, the federal legislation that the Biden administration is purporting to implement, we're not sure that the statute, the federal statute that Congress passed, and had been passed a long time ago, we're not sure that that statute authorizes the Biden administration to do that. And so if the Biden administration is going to issue this moratorium, Congress is going to have to say that that's what they're authorizing much more clearly. So it's kind of a clear statement rule. You really have to make it very clear in your legislation that even something like this is something that a president can do. That's a federalism ruling that's tilting the balance of power to the states. The federal government could still do it. Congress could still pass a law authorizing a moratorium like this, but we know how Congress is functioning today. We know that that's unlikely to happen. And so because it's probably not going to happen, it means that the states are left to decide that issue. It's not a matter of a federal rule. Here's my last story. It'll be as short as the last one I told. Just last month, or I guess we're in March now, so in January, a month and a half ago, the Biden administration had issued a vaccine mandate. All large employers, almost all large employers, there are some exceptions, but if you employed 100 people or more, those employees had to get vaccinated, right? And if they weren't vaccinated, you couldn't allow them into the workplace. The Biden administration took that action, relying, it believed, on some authority that Congress had provided in an older statute. And the Supreme Court relied on the same reasoning, dividing along the same lines, saying, as we read the statute, which has to do with preventing the spread of disease in workplaces and so forth, we're not convinced that it was things like this that Congress was thinking about. And so if Congress really wants to authorize that, today's Congress has to pass a law making it really clear that this is what it wants. And unless it makes it really clear that this is what it wants, this is basically an issue for state regulation. States can decide whether they want to have vaccine mandates or not, but we're not going to have a national rule about that until Congress makes it much clearer. That's a federalism dispute. Okay, so here's my last slide. I got 60 more seconds. I'm done talking. You have several different federalism lenses. So when you think about whether it's slavery, okay, or clauses of the Constitution and whether they do or don't take power away from the states, or vaccine mandates, other things that we've looked at here, there's lots of different ways you might choose to think about that. You can choose to think about it in party terms, about who holds the reins of power in a given state, and you might find that your federalism principles, if you're in a state where your favorite political party is really running the show, is probably in your interest to say, well, that's where this issue really ought to be resolved, especially if the opposing political party is holding the reins out there in the federal government. Okay, you can look at all this federalism, and say, isn't this a wonderful thing that on all these issues, like what to do about vaccines, what to do about evicting tenants, we kind of have a choice. We can decide through the politicians we elect. Going back to the Federalist Papers, we can decide to elect politicians who favor letting one government, the federal government or the states, control this rather than the other. We can think about an issue and say, okay, an issue like evicting tenants or a vaccine mandate, do we think of that where we ought to have one national rule? Or do we think of that as something where we should let the states make up their own minds, let states experiment, let people vote with their feet? Okay, so a range of different ways we can think about this. I'm going to rely on our Barb or whoever is moderating to see whether we've managed to provoke any interest at all here that would manifest itself in the form of questions or comments, whatever you have in mind. But Barb, I'll ask you to join us and see where you want to take things.
All right, thank you so much, Todd. Ann and Galen, what are you seeing there in the chat that you can direct to Todd? Are there questions or comments that you think are important to share with all of us?
We do have a few questions. And I guess this is general, but we have, and I think we might all still have this question, when there are issues that affect or impact the economy and health of the entire nation, which is sort of along the lines of some of the examples you gave, where the federal government made a decision, why isn't that a federal issue? Or is it a federal issue? I guess that's the confusing part, isn't it?
Yeah, well, the first thing we want to know is, remember I said at the beginning, there's going to be some issues, not many. There's going to be some issues that the Constitution says only the federal government can handle. There's going to be some issues, not many, that the Constitution is going to say only the states can handle. Most issues that we think of, not all, but most issues, we have a choice. It could be the states or it could be the federal government. So from a constitutional perspective, if you just say, what's the Constitution's answer to where should this be? The answer usually is going to be, you have a choice, American people. You can decide whether you want a state by state solution or a national solution. Okay, and so then once you get past that, now we get to the should. Well, where should we regulate? And so we take something like the pandemic, yes, a national problem, or unemployment, a national problem, homelessness, a national problem. We have to decide, are we confident that we know what the answer is? We're so confident that we know what the answer is, we don't need state experimentation. We shouldn't be giving the people the freedom to vote with their feet. We know what the answer is, this is the right thing to do, and so we need to adopt a uniform national rule. Is it that? Or do we say, boy, it's a complicated problem. There's different ways we could go. You know, we shut down the schools. How does that help? Or we have schools open, but we mask. Or we say, do what you want with masks. Do we want to say, well, let states figure out what they want to do? And we can go some months and see how things play out. And maybe we'll be a little wiser further down the road. We can either let regulatory pluralism continue or switch to a national solution. So the first question is, what does the Constitution dictate? And usually it's not going to dictate anything. It's going to say you have a choice. And then we're left with the should question. And we have all those different ways of looking at that. And so there's very infrequently one right answer dictated by the Constitution. It's a policy question about what do you want and what do you want your elected leaders to do?
Oh, okay. Todd, this is Galen, and I'm gonna read a question directly from the chat from Polly.
Okay.
It's interesting. What amendment addresses division between church and state?
The amendment, that's the First Amendment, which says that there shall be no establishment of religion. There's 2 religion clauses in the First Amendment. And that, by the way, the establishment, that's a great question. That's a federalism story to itself. I'll see if I can tell it in 60 seconds. The original meaning of that First Amendment, which says Congress can't establish a religion, probably meant, and there's some debate about this, but at the time the Constitution was ratified, there were states that established a religion, meaning they imposed taxes in order to build churches for a particular religion. They would pass laws saying you've got to be there Sunday morning. If you're not, it's a misdemeanor. You can't be working during that time, dishonoring the Sabbath, that's a misdemeanor. That, if anything is, that's an established religion. And so they were starting to go out of favor at the time of the nation's founding, but a number of states still had them. And so what that First Amendment probably meant was initially that with the Establishment Clause is, we don't want one national religion. We don't want Congress coming in and declaring one religion for the whole country. We want to allow states to continue to decide for themselves. Do we want a local established religion? No, well, we don't have to have one. We do want a local established religion. Which religion? Well, that's what we'll have then. It's not until well into the 1900s, 200 years later, almost 150 years later, that we start to think that the Establishment Clause might not even allow states to establish religions. But there's some federalism coloring to that. State level choices about religion, or do we want to say at a national level, nobody's going to be able to establish a religion? That's where we are now, but it took a long time to get there.
We have another question that really is looking at the idea of the court interpreting the Constitution versus Congress making laws. And that's Roe versus Wade, which is a ruling made by the court and not Congress. So is it a state or a federal issue? Or is it something that the Supreme Court will do? That's a confusing one for us to understand, I think.
Yeah, you know, the answer to that question is as controversial as the abortion question itself, by which I mean it depends on how you read the 14th Amendment. If you read the 14th Amendment in a way that assures a woman a right to decide whether to terminate her own pregnancy, and that is the constitutional text that this abortion debate focuses on, it's some language in the 14th Amendment. If you read the 14th Amendment as requiring that women be given the freedom to decide for themselves, then the 14th Amendment itself gives us a national rule. And the rule is women have to have the freedom to terminate their own pregnancy. So if you're on the pro-choice side, you're on the side of regulatory nationalism. You're saying as a national matter, the 14th Amendment gives us the answer to that question. If you are a Roe v. Wade skeptic on the pro-life side, and you don't read the 14th Amendment that way, you would say the 14th Amendment does not establish a national rule. And in the absence of any other constitutional provision that does establish a national rule, it is evidently a state issue. And so we have a case in front of the Supreme Court now where the court might very well decide to reverse Roe versus Wade. And depending on exactly what they say, that might mean that we move to regulatory pluralism. Now each state is able to decide for itself. And so whether it is a national issue or whether it is a state issue is itself the very question that makes Roe versus Wade controversial. Roe versus Wade said there is one answer to this question. Women nationwide have a right to terminate their pregnancy. And those who think Roe was wrongly decided by and large think that is a matter for states to decide on their own.
All right, thank you.
It's not, I understand you sighed. It's not satisfying in the sense that it'd be nice for someone to come and say, here's the dictated answer.
Yeah.
But the truth is, it depends on how you read those kind of national constitutional texts, those national texts, how you read federal statutes, how you read the federal Constitution, and do you read them as adopting a national rule or do you not? You know, so I could take a position tonight and say, well, here's what I think on the abortion question, whether it's a national rule or it should be state by state, but that's just Todd taking a position. You know, the truth is we got to decide how we interpret the 14th Amendment and whether there's a national rule there. And if it is regulatory pluralism and we don't like that, then we would need a constitutional text akin to the 13th Amendment on slavery that declares, here's the national rule on abortion, one way or the other.
We have just one other question, I think, asking about the constitutional sheriff's movement.
You have to tell me a little bit about that.
And I don't know what that is either. It asked you if you would comment, but I don't have any other information.
There's nothing more fun than looking ignorant in a live event, and that's what I get to do right now. I don't know enough about it to be able to comment.
Perhaps the person who wrote it could speak up.
Yeah.
Could they be unmuted and tell us what that's about?
They'll have to probably type it in, I think.
Susie, can you unmute that person?
I'm going to try.
Okay.
I'll just response to your comments about your so someone says that, so if all of this is very much a matter of opinion and interpretation, isn't the Supreme Court, the body that ultimately decides these questions, a very political body?
In many ways, that's absolutely kind of inescapably true, insofar as the Supreme Court has claimed for itself, and we have allowed it to claim for itself, that it has the last word about what the Constitution means. And so it's going to make choices that we will either find politically favorable or unfavorable. We'll praise them or we'll criticize them. And so they are very much engaged in issues that are political issues. They don't think of themselves, of course, as politicians, and we can decide for ourselves whether they actually are. If we say that they are, what that typically would mean is they kind of do what they want to do, and they read those texts however they want to read them to kind of vindicate their own preferences. And you know, people can decide for themselves whether that's what courts are doing. But they're very much involved in issues that are within the political realm. And really what their job is to decide on abortion, for example, when does the Constitution take something out of the realm of politics? Roe versus Wade took abortion out of the realm of politics and said, as a constitutional matter, states can't deny women the right to terminate a pregnancy, at least during the early periods of pregnancy. That's taking the issue out of politics. Roe versus Wade critics say that issue belongs right back in politics. And so the Supreme Court should reverse Roe versus Wade and restore this to the political realm. Those who like Roe versus Wade are going to say, what a political thing to do. You took a position on this issue and we had it, what we wanted. Now you've given it away.
All right.
And did you see the new one about the latest Iowa ban?
The one before that was about California's law banning the sale of pork from producers using gestation crates. And will that be upheld?
If they're barring it coming in from other states, I'm going to assume that. Yeah.
I'm going to assume that as well, but.
Yeah, there's a constitutional doctrine. It would be too complicated for me to get into the details, but if people want to Google something, you would Google or use your search engine of your choice, the Dormant Commerce Clause. The Dormant Commerce Clause is the name of a constitutional doctrine that places some limits on states' ability to restrict trade passing across state borders. And so when a state says anything sold within this state has to meet certain requirements, there is a constitutional doctrine that asks whether that is something that states are allowed to do. And so the answer to that particular question in California is going to be a maybe. We'd have to look at exactly what the state is doing. We'd have to look at that constitutional doctrine. And there again, we'd be saying it's possible that the Constitution, under this doctrine called the Dormant Commerce Clause, is adopting as a uniform kind of national rule that on those kinds of issues, states don't have a voice. Mm-hmm. Or it could be that no, states are allowed to impose these kinds of restrictions. I'm telling you, when you start to think about things through this federalism lens, it's everywhere in our politics about how we interpret statutes, how we interpret constitutional provisions. Always, often lurking in the background are implications about whether we're leaving power in states' hands so that states are free to do what they want, or whether we're taking it away from them, or if the Constitution lets us choose, we're left with nothing other to do than to elect politicians at both levels of government who favor the policy outcomes that we want. Because if an issue is something that Congress can regulate if it wishes, we're better off putting like-minded people there. If states can regulate it if they wish, we're best off putting like-minded people there. And so the best day is when politicians from your political party are controlling both of those levels. Okay, you lose power at one level, then you face a threat. You face a threat that the politicians you regard as unfavorable are going to choose to regulate the area that you care a lot about, and you're not going to like the way they regulate it. And when that happens, whether you realize it or not, are going to start to speak the language of federalism and say the other government ought to take over, and they should start passing some rules.
I'm gonna bring in a question that is completely new, or I mean, just happening in Iowa right now, and this is it. Todd, can
Okay.
you comment on the latest Iowa ban transgendering girls or women competing in women's sports? Does this conflict with the federal anti-discrimination law in your opinion?
I don't. I have casual views about that, but I'm not going to shoot from the hip with casual views. It's a complicated issue. I'll just say that it's a complicated issue, and leave it at that. And a very important one. I don't mean to be dismissive of it, but I don't have a view that I'm feel comfortable enough about its soundness to say, here's what I really want to kind of push people to think. I would say I'd want to study that more carefully than I've been able to yet before I say something publicly about
It will go through the courts, do you think? And
Yes.
yeah.
Yes.
And it maybe be drawn out.
Yes, and the question asker, the person asking the question referenced federal legislation. There's also an equal protection clause issue, because we have a state doing something that may or may not be treating people unequally under the equal protection. So there's a constitutional question, there's federal anti-discrimination legislation. There's an awful lot of complexity that has to be sorted through there.
Okay.
All right, we have maybe one more question, which is near and dear to the League of Women's Voters' heart. It's about voting rights, and you've put a lot of stress on political parties and essentially voting the policies that you want. So if one of the political parties is no longer viable or functional in the traditional sense, then how can the system work to address voter rights?
That's are there many more important questions than that in our democracy today? I don't know. That's hugely important. You can shift that question just a little bit and think about partisan gerrymandering, where the question is framed in a way that one political party has ceased to function effectively. Really closely related to that is what happens when a party, it's often been Republicans, but there's areas where it's been Democrats too, control the district drawing machinery. They've got computer assist programs now that enable them to draw district lines with incredible precision that make it impossible for the other political party to regain control of the state legislature unless they win a real supermajority. So just winning 51%, not enough. In some states, you need a lot more than just a majority of the state citizens voting for the out of favor political party for them to be able to regain control. And the Supreme Court looked at that, looked at partisan gerrymandering and said, does the Constitution adopt a uniform national rule, basically placing limits on states' ability to draw district lines based on partisan identity in an effort to favor one party or another? Or does the Constitution leave states pretty much free to do what they want when it comes to partisan gerrymandering? That's a federalism question. Does the Constitution impose some restraints? Or does it leave, like on abortion, does it impose some restraints? Or does it allow states to do what they want? And the Supreme Court, on party lines, decided that the Constitution does not impose restraints, or at least that the Supreme Court did not find any constitutional standards that were clear enough that it felt comfortable enforcing. And so right now, at least, and for the foreseeable future, states, we have regulatory pluralism on partisan gerrymandering. States can decide for themselves. Iowa's been pretty good about this, the way we draw district lines. Do we want to keep that? Or do we want to abandon that so that we can start getting more in the partisan gerrymandering game? We have regulatory pluralism on that. So some states are being very heavily gerrymandered. Districts are becoming less and less competitive, where one party is pushed largely out of power. And that makes state level politics, for that disfavored power, it really takes a lot of federalism's benefits away from them, because they're supposed to have a choice where they can get what they want at the state level or federal level. at least on partisan grounds, you push someone out of power far enough, you're saying you've just lost half of the split atom of sovereignty that Justice Kennedy was talking about. You really only have one political capacity that left, and that is the federal government. It's a loss.
Oh, boy.
When you're on the losing side of that political party. If you're in the political party that has gained favor, then federalism looks like a sweet deal. You really do have everything that Justice Kennedy described. You've got the state machinery at your disposal if you want it. If you can win at the federal level, then you're going to have power there too. And so where would you rather exercise power? You can have everything.
I think we need to wrap up tonight, Todd. I cannot thank you enough. My head is spinning. My notes are profuse. It's been a wonderful, challenging, and interesting evening.
Thank you.
Exactly what we have lots to talk about afterwards and think about. And I so appreciate you being here. Thank you so much, Professor Pettys.
It's my pleasure. And if you watch it a second time, I hope there's something there that makes it worth the effort. But I had such a lovely time with you tonight. And thanks to all of you for attending and for caring enough about these issues to hopefully walk away with at least one or two things to add to your already rich body of knowledge about our system of government.
Thank you.
Thank you.